A big estate planning mistake parents make is naming guardians for their minor kids only in a will and not naming guardians in any standalone guardian nomination document. Let's talk about why. Hey guys, Elliott Feldman here, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. If you ever have any questions about this topic or need to talk about your estate planning needs, you can schedule a time to talk with me over the phone for free by going to myestatemeeting.com. Okay, let's talk about why it's a mistake for parents to name guardians for their minor kids only in a will and not naming guardians in any standalone guardian nomination document. So most traditional estate planning lawyers are putting all named guardians only in a will, but the first problem with this: where is the will even located when somebody dies? Let me illustrate this with a story. Mom and dad got their estate plan created by a traditional estate planning firm who helped them nominate dad's sister, Georgina, in their will as the long-term guardian for mom and dad's minor kids, so that if mom and dad both died while their kids were still minors, Georgina would raise the kids as the guardian. Now, mom and dad keep their estate planning documents in their storage locker, where they keep all of their other legal documents and tax returns and deduction receipts, so that the estate planning documents would not go misplaced in the house. But mom and dad never told anyone, let alone Georgina, that they were keeping their estate planning documents, including their will, in the storage locker. At some point in the future, mom and dad planned a date night to have dinner together and hired a babysitter to watch over their minor children at the home. Later that night, they finish dinner and head back to their house when they are T-boned by a semi-truck driven by a drunk driver, which killed them both instantly. So the police eventually show up to mom and dad's home to deliver the news about mom and dad's tragic accident, and the babysitter answers the door and doesn't know what to do, and no one can find where mom and dad's will is in the house, since it's in that storage locker that no one knows about. And now the police find out that Georgina is dad's sister, and they call Georgina to tell her the bad news about mom and dad's tragic accident. And the police ask Georgina if she knows where mom and dad's kept their estate planning documents in their will that potentially name long-term guardians of the minor kids. That's when Georgina tells them that she has been named as the guardian of mom and dad's kids, but does not know where mom and dad's will is located. That's when the police tell Georgina the bad news that unless she can present the will that nominates her as the guardian or has been named as guardian of mom and dad's kids in a standalone guardian nomination document, then they will have no choice but to take the kids into the care of strangers at Child Protective Services until the will nominating Georgina as guardian can be located, or unless Georgina can be nominated by a court to be the guardian of mom and dad's kids. Again, if mom and dad had named Georgina to be their kids' guardian in their standalone guardian nomination document and gave that standalone document to Georgina, then Georgina could have presented that documentation to the police and taken custody of mom and dad's minor kids to prevent them from being taken into the hands of strangers at Children's Services. Now, the second problem with failing to nominate minor guardians in a standalone document is: what happens if mom and dad didn't die in the car accident, but they both ended up being incapacitated in a coma at the hospital? Remember, a will only takes effect to nominate a guardian when you die. And in our case, if mom and dad are both still alive but incapacitated in the hospital, their will doesn't even take effect to nominate Georgina as the kids' guardian. So in that scenario, Georgina, once again, would need a standalone guardian nomination document that names her as guardian that is readily accessible to her to take custody of the kids. Otherwise, the kids will end up being taken into the hands of strangers at Children's Services until Georgina can get nominated by a court to be the guardian, or find mom and dad's will that she has no idea where it's located. Hey, thanks so much for taking the time to watch this video. Don't forget to hit that subscribe button and the notifications bell next to it to be notified for new videos I post each week. And if you like it, then please hit the like button. And if you know someone that needs to hear this, please share it with them. If you have a question or comment, please leave it. And if you ever have any questions about this topic or need to talk about your estate planning needs, you can set up a time to talk with me over the phone for free by going to myestatemeeting.com. That's myestatemeeting.com. Again, this is Elliott Feldman, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. Take care.